Good evening. This is Laws 12062, Alternative Dispute Resolution. We're into week 7, and this week we deal with a whole range of different topics, all to do with ADR. The thing that's, I guess, daunting about ADR, in a sense, is that there are so many different procedures available to participants that if you're an advisor, you need to understand how these things work so that you're in a position to provide them as an alternative for your client to consider. If you're an ADR practitioner, you need to consider them so you can determine whether this is an area of practice that you would like to be involved in. And if you're a litigant, you need to be aware of these procedures because it might be proposed by the other side and you need to know something about it, or you need to be able to propose it to the other side. So there's a whole range of options here. And the thing that I notice in Spencer's book on page 3 is the chart. I think I may have shown you that before. So that shows you from the top right, the least interventionist, down to the bottom left, the most interventionist. And I've numbered them. 1 is negotiation through to 14 arbitration. So tonight we deal with a whole range of those different topics there. We've concentrated on mediation, conciliation, negotiation in the first 5 weeks or so. We then moved to arbitration last week. This week we deal with partnering, dispute advisors, dispute review boards, conciliation, not really, collaborative law, expert appraisal, expert determination, early neutral evaluation, referencing out, and also restorative justice, which isn't on the list. So we better move into it pretty quickly. Those of you who attempted some answers in relation to the questions that I raised, thank you very much for doing that. I appreciate that. Let's firstly talk about collaborative law. What is collaborative law? Who's worked out what it is? And more importantly, please tell me how you would see collaborative law working in practice. You, being a practitioner, how are you going to use collaborative law in your practice? Any thoughts?
Hi, John, it's Jessica. I will
Hi,
give
Jessica.
you thoughts. I think it seems to predominantly be used with family law at the current time, though it does seem to be developing to further afield than that. And in terms of what it is, it's where lawyers and their clients get together and essentially, I guess, negotiate a path to a resolution, with the understanding that if it went to litigation, those professionals who are involved during the collaborative law stage would not be involved in the litigation.
Very good. So if you were advising a client to proceed to collaborative law, what are some of the advantages and disadvantages over collaborative law, say, than mediation? Any thoughts? I'm making you work tonight, aren't I? I'm sorry. All right, so let's say you're just talking to a friend. A friend is crying on your shoulder, so to speak, saying, I've got a family law problem. I don't know how to resolve this. Would you suggest mediation or collaborative law? We can have a vote if you like.
I think that's a hard question to answer without knowing the facts, because each case is different.
That's a great response.
Perhaps typical lawyer response. I think if you're perhaps at least on speaking terms with, say, an ex-partner, for example, collaborative law could be a good way to go. If, however, there's a lot of tension in the relationship, mediation might be better.
Yep, that's a valid point. And I think you're right, Jessica. It does depend on the circumstances, and there might be a whole lot of factors that come into it. Is it a fair comparison to consider collaborative law as an alternative to mediation? Can we have both? Can we have mediation within the context of collaborative law?
Yeah, I don't think they are necessarily mutually exclusive myself.
Yeah, I agree with that. And I think in the context of collaborative law, it's quite possible and quite usual to have a mediation session. So in the collaborative law agreement, it may be that the parties agree to engage collaborative lawyers. They have a participation agreement, and in that agreement, it might provide for a number of joint sessions between the parties and the lawyers. They work out some issues. If they simply can't resolve it, then there might be a mechanism for engaging a mediator to assist the parties to come to a resolution. So, yeah, you're right. There are a whole lot of combinations and permutations available in this sphere of practice. Has anyone looked at websites in relation to collaborative law? Given some thought, has anyone decided that they would like to be a lawyer that practices in collaborative law?
I think there is a certain appeal there because at the same time this semester I'm also doing legal advocacy, which is all about litigation. I far enjoy the idea of collaborative law better.
Yeah, there's nothing quite like the adrenaline in a good fight, though, if you do it the right
Yeah, that's
way.
definitely adrenaline and nervousness when you have to get in front of a judge. But I think this way is probably, I'm not sure if I'm using the right term, but almost a bit more peaceful because I think you can come out the other end kind of not to be all like rainbows and sunshine, but you can come out the end still being quite friendly with someone else. And there's
Yeah,
not,
and
may not necessarily be animosity, whereas litigation, it would be opposite. It'd be rare to still come out quite friendly.
yeah. Look, I think there's a fair point to that. With litigation, it's almost as if you've got the parties running along parallel but separate railway tracks, not actually meeting until they get to the end, the station, if you like, which is the courtroom. So anything that allows the parties to connect across those railway tracks, if I can use that analogy, is probably a good thing. Collaborative law is a process where that joining between the railway tracks is built into the process. People expect it. That's what's going to happen. It doesn't come as a surprise when there is a meeting between the parties. Mediation's a bit the same way too, in that you're trying to join the tracks. So the traditional process of litigation, adversarial litigation, is the parties prepare their separate cases, running towards the end, and only at the very end do they join. Mediation and a whole lot of ADR practice has come about because it was obvious that parties were resolving matters on the doorstep of court. It was really the first time they got together, but that came at a huge emotional and financial cost. So if you're advising a client in relation to collaborative law, you might want to think about how this might provide some advantage. You need to think about how you would go about that practice. And for the sake of what might be in the take-home paper, you need to think about what you would do to establish a collaborative law practice if that's what you decided to do. So the take-home paper will be all about either providing very specific advice to clients, a client or a number of clients who have a dispute problem, and you've got to provide them with advice as to which way you think they should go, out of a whole range of different options within the ADR context. Or the take-home paper may be, you're now a lawyer, you want to practice in this area. What are you going to do? How do you go about doing it? What are the advantages that you can offer to clients by adopting this type of practice? Okay, are there any other questions, comments in relation to collaborative law? But you're right, it did grow out of family law context, and some steps identified on page 170 of the text. All right, let's move on to the next one, which is dispute resolution advisor. What does this mean? What's a dispute resolution advisor? Any thoughts? The textbook provides some good examples here in relation to the contracts in Hong Kong. So on the scale of 1 to 14 that I showed before, 1 up here being the least interventionist, and 14 down here being the most interventionist, dispute resolution advisors right up near the top at number 3. So what that tells me is that this is one where the parties are left to resolve the matter themselves to a large degree, but having a dispute resolution advisor helps considerably because, like collaborative law, you've got a program built in where the parties have an opportunity to discuss things. What's interesting about dispute resolution advisors is it's a form of ADR, potentially, where there is no dispute. I think it's amazing. And it's a real area, same as partnering. Partnering's the same. So you can have no dispute whatsoever, and yet, as a lawyer, you're providing advice to a client to engage in a process which involves dispute resolution advisors. Now, why would you do that? Are you creating unnecessary cost, expense, and complexity? Or are you offering a real solution? What are your thoughts?
I think that it's a proactive step to avoid dispute in the first place.
Absolutely. When do you think you would suggest that a client consider appointing a dispute resolution advisor?
I think it could be similar to a circumstance such as like when you're buying land and you have certain clauses in a contract. It's defensive rather than attack. So that circumstances that could happen but actually haven't happened. It's the potential.
Yes, and these sorts of things provide you with an opportunity to be inventive in the way you go about providing your advice. Traditionally, dispute resolution advisors were involved in the building industry, large-scale contracts, but like many of these things that have developed over time, they're now being used in a more wide application, and that's being inventive. So a dispute resolution advisor provides a really quick way to resolve disputes. And one of the, I guess the key point firstly is that it's done at a time when the people are talking. And that's a real bonus. You can get more if people are talking. If people are not talking, you've got to overcome that hurdle to get them talking before you can have a resolution. So why not build in that process while they're talking? And it may never be used, but as Gordon said, it's proactive, and that's a good thing to consider in the context of trying to advise your clients. So have a look at the dispute resolution advisor model that was developed in Hong Kong. Some comments in Spencer. I think a chart in figure in page 151 that you might look at, and that gives you a model as to how it could be used potentially. Okay. Would you like to practice in the field of being a dispute resolution advisor? And if so, how would you do that? Would you advertise in the yellow pages, dispute resolution advisor? How would you go about starting a practice in that field? Any thoughts?
Wouldn't you have to have some sort of expertise in that specialized in that specialized area?
Well, and that might be one of the questions in the take-home paper, as to whether you do need that expertise. So again, coming back to that fundamental thought that in the take-home paper, I want you to be thinking about how we can use these things in practice. That might be one of the questions to consider. So when you're reading this material, I want you to read very actively, and again, with the risk of repeating myself, number one, think about it as if you're a lawyer advising a client, either to go into this process or explain what the process is all about. That's one thing. The other thing is, if I wanted to practice as a dispute resolution advisor, let's say, how do I go about it? Do I need special expertise? Is there a market? So when you're reading this stuff, don't just read it, but read it really actively in that context. Let's put some meat on this. Let's give you an example. the Australian Competition and Consumer Commission have a number of processes that provide some formal means of resolving disputes. So it's the ACCC being very proactive. One of them is the Office of Franchise Mediation Advisor, which is a specialist body that provides mediation services for people that are involved in a franchise dispute. I happen to be on the panel. I'm one of the panel mediators for the ACCC through its OMA program. So I deal with franchise disputes. But the ACCC also deals with dispute resolution advisors for industry. To give you some idea of this, let's have a look at the web page, and I've got to share the screen here. Let's see if I can do it properly this time. Can you see the ACCC screen there? All right. What you'll see there is that the ACCC have a role in dealing with the special access undertaking involved in the NBN process. And it provides jurisdiction to deal with a number of dispute resolution advisors in that context. You'll see that here, on the 3rd of April 2014, the ACCC made a decision to approve the appointment of NBN's proposed resolution advisor, Professor Tanya Sorden, and the resolution advisor terms of appointment. So Professor Sorden is very well known as an academic in this field of ADR practice. So perhaps coming back to your comment, Gordon, I'm not sure that Professor Sorden is actually registered as a dispute resolution advisor, but certainly Professor Sorden is now appointed as the resolution advisor in that context. And you'll see that it goes on to talk about having terms of appointment and an approved pool of members to assist in the mediation process or the dispute resolution advisor process. And there's a list which contains many senior counsel members. Also, you'll see that there are a number of documents, and one of them are the approved dispute guidelines in relation to the dispute resolution advisor format for the ACCC to deal with NBN disputes. So I guess you look at this and it really comes home to me how proactive parties can be now in trying to deal with ADR alternatives. And here we have a massive program, NBN, with the approved dispute guidelines, and it's still, so it sets out the background, the introduction. So it may be that the take-home paper requires you to give consideration to this document. Ask yourself, how does it come about in the first instance? How is it used? How are these people that are nominated? How do they become nominated? How would you like to be someone who is nominated? And how would you advise clients if they're involved in this type of dispute? Going further, the take-home paper might be something like you've got a number of people that are involved in a substantial project, and you might have to consider the option of creating something like this dispute resolution advisor agreement. So that's the sort of thing that I want you to think about in the context of the take-home paper. So are there any questions or comments about that? I know I'm being a bit vague, but that's intentional.
Hi, John, can you hear me? Hello?
Hello, we can just barely hear you.
Oh, yeah, just, can you hear me better now?
We can hear you, Andrew.
Yeah. So just in relation to that, it just seems like the people that were nominated, they all seem to be senior counsel or Queen's Counsel members. So would that basically kind of say that the people that actually are practicing as advisor dispute resolution, well, ADR dispute resolution advisor, sorry, will they tend to be quite sort of lengthy kind of lawyer, like they've been around for quite some time, like they've gained the respect of their fellows?
I think absolutely. And certainly in this context, we're looking at dispute resolution advisors at the big end of town, if I can use that term. So we're dealing with very well-known, very well-credentialed people. And while it may be a wonderful job to have an opportunity to work on something like this as a dispute resolution advisor, there is the option of looking at the same sort of model, but now on a micro scale. And ask yourself this sort of question: if I wanted to be a dispute resolution advisor, can I come up with a model that would work in a totally different context, but something that is more achievable? So, yeah, we could all aspire to become senior counsel and then put ourselves forward for that type of thing. But, you know, there are so many disputes. And you might say, well, look, I think this model could work in relation to school disputes, disputes between parents and staff, or between employees. I think this model could work. So part of your role in this course is to be very inventive, think about how you can use these in a practical sense. In other words, the complete opposite of a question that says, name 6 different dispute resolution methods and provide me with an outline of the advantages and disadvantages. So you're not going to get that. It's going to be much more inventive than that in terms of the take-home paper. So thank you for that question, Andrew. Are there any other questions, comments? Okay. All right, so that's the dispute resolution advisor. Let's have a look at dispute resolution boards. So what's a dispute resolution board? Where does it fit on the number? And what type of industries look out for dispute resolution boards? Any thoughts? Some tough ones tonight, I know. All right, so have a look at your textbook in relation to dispute resolution boards. Ask yourself some basic questions. For example, you know, are these bodies inquisitorial or adversarial in nature? Are they determinative? When do they come in? Is it preemptive? Is it something that's after the dispute was finalised? And try to find some real life examples of these things. So look, let's have a look at, say, the Dispute Resolution Board Foundation. I'll share the screen. We'll go to the correct screen. We'll now have a look at the link for the Dispute Resolution Board Foundation. And you'll see there that it was founded in 1996 as a global not-for-profit organisation dedicated to promoting the avoidance and resolution of disputes. And the initial focus was to assist parties to construct contracts to improve outcomes in projects. And as these concepts have developed, they come to be recognised as beneficial to any commercial contract with elements of uncertainty, where the contract is to be conducted over a considerable time. And you can read more about that by clicking the link on the website. So there's some comments in relation to dispute resolution board, and you can join. Now, the take-home paper might be something about what are the benefits of joining the Dispute Resolution Board Foundation. How could you use that in practice? How could you advise that to be used by your clients in practice? How much does it cost to join? You know, what are the tangible benefits, etc. So again, looking at the big end of town, we see some examples of dispute review boards and some projects there: Gateway Express in Brisbane, desalination plant in Sydney, Sydney Ports expansion and suburban train sets. So they're big end of town. But again, the focus that I want you to think about is also, how can I use this on a smaller scale? Where can it be used? And should I promote a dispute resolution board solution to a client, or should I recommend a dispute resolution advisor or partnering? So it's a matter of knowing the differences, but having some concrete thoughts as to when and how and why and how much it would cost to do that. So lots of active reading required. Okay, I know I'm hitting you with lots of things. Millie says building and construction matters, and I agree with that. I think that what we've seen tonight in the alternative different types of dispute resolution, it's mostly been, I think, family law at the start and construction. But in both instances, and I'm talking collaborative law versus the others, the commentaries reflect the fact that these are ways of resolving disputes proactively and reactively that have stemmed from different areas of practice. But now people are thinking, hang on, we can use that model in a different way for a different area of dispute resolution. So that's what we're really all about tonight. So as a lawyer, you might think to yourself, how can I get involved in this? For example, cynically, it might be said that collaborative law was created as a response to the work that was being lost by mediators, by lawyers to mediators. So cynically, one might say, well, the collaborative law movement was created by lawyers so they could keep control of the dispute and therefore generate the fees. I'm not saying that is the case. I'm just saying that's an argument that might be put forward. But it all comes about by someone being inventive and thinking of how to use things in a different way. Okay, you're being very patient with me. I'm talking more than I want to. Are there any questions, comments? No? Are we looking forward to the take-home paper? Yes, that'll be fun. All right. Let's talk about partnering. Now, partnering's number 2 on the list of our options. Number 2, right up the top. So partnering is about as far away from traditional litigation as you can get. Can anyone give me 2 words that are the key points, the key aspects of partnering that make partnering different to everything else? I'm looking for 2 specific words here. I'm sure you've all done your homework. Mutual objectives, says Michelle.
I'll throw teamwork and cooperation out there.
Teamwork, cooperation, and cooperation, says Jessica. Thank you. Likely problems, says Peter. Good faith, says Gordon. Yep. These are all good answers. Improved communication, charter. Well, charter's one of my 2. Stakeholders and charter-based. So Terry and Grace. Commitment and communication. These are all really good things. Good faith. Okay. The 2 words that I had in mind, that I took from it, this is not necessarily the answer, this is just what I took from it, was a workshop and charter. That, to me, that's what makes this a bit different to other forms of ADR practice. So it's a form of dispute avoidance, isn't it? It's not really a dispute resolution. Partnering is more a dispute avoidance situation. And it sets up, like the others that we've talked about tonight, a process, a procedure, particularly at the stage where people are, on good terms. And I guess really all of these things, dispute avoidance procedures, come about because there's a recognition that we're all people. There are emotions get involved, money gets involved, stress, third parties. Things can go off the rails pretty quickly. And where we're talking about something that's very important, it's good to have the framework set up so that we can deal with those disputes quickly in an effective manner. I think setting up a partnering practice would be an excellent opportunity. I don't know, are there any partnering practices out there? That might be something for the take-home exam. Okay, so partnering specifics, I mentioned the two that I had in mind, not necessarily the answer, but just the ones I had in mind, was a workshop and a charter. So what's this workshop? How does that, what's a workshop mean?
Everyone gets to know each other and work and look at the outcomes or objectives of the project are.
Very good. Yep. Sounds a bit old-fashioned, but the team building is part of it in the workshop. Other things that we're looking for in a workshop involving partnering?
Could you say trust building, perhaps?
Yep, trust building, absolutely. Because people are more likely to resolve a dispute if they know each other and they trust each other. So if you're involved in a commercial transaction, particularly one that will take some time, look, it might be you're advising some developers over a lengthy development process. You know, maybe partnering is a good way to go. So thank you, Jason. Any other? Building relationships, says Gordon. Okay, so in a workshop, I think you need to have an agenda. You need to identify a location, and that might be kind of a nice place to be. You need to have some sort of facilitator to run this workshop. So that might be a good thing to do for a living. Team building exercises, but importantly, I think you need to put it on the parties to say, look, what are your interests in this process that you're about to go through? And one of them might have, in a commercial context, may have had a very bad experience where receivers were brought in at a stage where there was tension between the stakeholders. So one of the interests of the parties, they might say, well, look, whatever it is, we don't want receivers. So we've got to be able to resolve things without having to bring in, the third parties like that. So having some sort of identifying their interests and identifying the issues of concerns are all sorts of things that might be done in a workshop. And Jessica says, go to Fiji. Well, yes, that would be nice too. Right, charter. The second thing I said was charter. What's a charter? Why would people want to have a charter?
It's almost like a contract.
I just missed that, Gordon. Sorry.
It seems to me almost like a contract, a contractual agreement to proceed in a certain way with respect to any disputes that arise.
Exactly, but probably even a bit more than that. So a dispute resolution process in a contract is quite common. I think in a charter, as the partnering expert, you're encouraging the parties to go beyond that. So we talked about team building, collaboration, commitment, communication, all those good things. Look, sometimes, and this might seem a bit silly, but sometimes it's really useful to actually just say these things. So, for example, Molly said before, commitment and communication. So in a charter, you might have a memorandum of understanding, if you like, between the parties to say, we resolve to be committed to the process and we are resolved to communicate with each other. And by asking them to sign this, it's almost like a pledge. It can be quite powerful. Now, you might think, oh, it's all very corny and it's not going to work in a commercial context. But I think most people around a room, creating a charter, a way of dealing with issues with looking directly into their eyes and a handshake, it can be pretty powerful. So it might just work. And in the charter, not only set out the ground rules for communication, but ways to review the process on an ongoing basis. Okay, so Jessica said, yep, sorry.
Oh, sorry. Is it, you mentioned MAU before, is that what it's effectively like? Is it just another description of an MAU?
I think so. I think it's a way of resolving issues, but kind of more on a personal basis. So partnering, of course, is number 2 out of 14. It's right up there as least interventionist. So it may be that it's not necessarily legally binding, but it's almost a code of conduct as well. But yeah, along those lines, Terry.
Yeah, okay. Thanks.
Okay, so, and Jessica says it's a framework, a guideline for fundamental principles. Yep, that's right. So at an international sphere, we have treaties, we have, and they're not necessarily binding, but member states sign them and they take it seriously. So if it's good enough for international law and member states, sovereign states, why can't it be used in the context of 2 people that are setting up some sort of business together? All right, let's move on to appraisals, evaluation and determination. Appraisals, I've got 9 from 14, so it's getting down near the bottom. Expert determination is 10, and early neutral evaluation I've got as 11. So these are getting all closer towards litigation. So appraisals can be binding, can be non-binding. Anyone have any ideas about when we should use appraisals or expert determination or early neutral evaluations?
When the parties have failed to come to an agreement and you need outside expertise to assist?
Yep, I think that's a very good point. For example, in determination, we really are looking at getting industry experts involved in the process. When you need to consider likely outcomes, that's a good point. So you're getting some expertise in that regard. It can be privacy issues can help as well. So you're not taking a dispute into the public sphere. And it may be a cheaper process. For example, expert determination reviews don't require a written reason. And the decision remains private. So have a think about those sorts of issues. If you were now let's see if we can meld these different concepts, because you don't have to come up with a solution that is, for example, early neutral evaluation alone. You can have hybrids, you can mix these up as much as you like. So you might come up with a proposal to assist some parties which involves some aspect of a dispute review board and some aspects of early neutral evaluation. We saw the situation in relation to the approved guidelines for the ACCC for the NBN project, where they actually had a list of people that could be called upon in the event of difficulties. So why not come up with a list of people that might assist in terms of expert determination at an early stage? So if you're coming to assist the parties in resolving an issue, then maybe you can come up with those sorts of, a list of names from the outset. Just an idea. Okay, so then we go on to court-appointed referees. Referees are really referencing out is a means of taking a specific issue, normally through a court process, and asking for a determination about that specific process. Have a look at the UCPR provisions, and the Civil Proceedings Act has some guidelines there in terms of referencing out. And adjudication is specifically for the building industry, primarily. We have adjudicators at QCAT, and I think I'm not an adjudicator, but they work very busily in building disputes. The other thing that we haven't talked about so far, and it's the last thing you'll be pleased to hear, is restorative justice. And there have been substantial changes in restorative justice in Queensland, particularly in relation to youth justice conferencing. So the ability to have a youth justice program, as we used to call it, has now been reintroduced into legislation just in the last couple of months. And it means that, for example, a young offender can be offered this ability to go to conferencing. Now, it might be seen as a soft option, but it does provide victims with an opportunity to see the person who caused the harm to them. Might have been a burglary or a stealing or something. It also works the other way, that the child can see that there is a real victim here. And there are many advantages to it. So in your take-home paper, you might be called upon to discuss the advantages, the disadvantages, the use of restorative justice. How does it work? How much does it cost? If you're acting for a victim, would you recommend it? If you're acting for a defendant, would you recommend it? If you are required to advise a politician, how would you frame this? Would you say it's good policy? If it is good policy, why does it help in the overall functioning of society? Can it be used on a private scale? Is there scope for restorative justice in private disputes? For example, and it might be, say, domestic violence or stalking or something. So the whole range of different things that you might consider in that context. All right, again, I apologise for speaking so much tonight. I'm about to wrap up, but are there any questions before we do wrap up? And I thank you for your patience.
Hi, John. I have a question.
Yes, Jess?
We've spoken quite a bit tonight about potentially what could be in the take-home paper, and you've spoken a lot about it being inventive and it like quite engaging and that sort of a thing. Because we have the 4 days, I don't know, it seems a bit clear to say, but I live in a rural area, so will most of it be online work? Like, we'll be able to research stuff online? Because I know for me, like, sometimes when we're asked to, like, go sit on a court session, I have to, like, plan that weeks in advance because you usually have to go to a metro area, which is a 6-hour round trip for me.
Yeah, look, the idea of it is that I expect you'll have to go online. If you don't have access to online facilities, that's going to put you at a disadvantage, I've got to be honest. So, for example, last year the exercise required people to contact actual practitioners and get an idea of how much something would cost and how long it would take. And that required some online research, and actually people got on the phone and spoke to practitioners. And while that may have driven some practitioners mad, the feedback that I got generally was that it was pretty useful exercise because it actually gave some reality to the situation. So you could probably expect something similar along those lines.
Okay, no, that's okay. As long as it can be done via telephone or via an internet connection, I've got no problems with that. It's just if we had to, like, physically sit or meet or observe something.
Oh no, it's purely an individual process. It's not a team process in any way. You don't have to go and sit and watch a mediation or anything else. But no, it'll be online research, advice, and speaking to practitioners.
Okay, and if the question does involve maybe speaking to practitioners, what happens if some of the practitioners that you do contact are a bit cagey or a bit huffy about spending time with you? Is there an option to actually say that in your take-home paper if you've still attempted to fulfill the requirements?
Absolutely. And, some people will strike it lucky. Some of the feedback that I got was I got onto a practitioner who was extremely helpful and took me through the process, told me the costings and others. Some others said, look, I tried 3 and they were all grumpy at me and didn't help. So I'm sorry, but there is going to be that aspect of it. But that's the exercise is meant to be realistic. So I can't make a realistic exercise and control the outcomes entirely. I hope you understand that problem. But my desire...
Yeah, absolutely. It doesn't bother me if I'm rejected as long as it's not reflective of the fat mark that I get if I've still attempted to do it. Because I know sometimes you go and ask a court clerk and they're really helpful, and other court clerks are just really not. So, I'm assuming it could be similar to that, but as long as, you acknowledge that.
I do. No, I totally understand. And look, some people said, I tried several times. I seem to be coming up against a brick wall. So what they did is say, I've gained enough to be able to create something that's theoretical. So, and you can do this. I'll be happy with this. So some people said, I spoke with this practitioner, and as a result, I've got these actual real costings and real timeframes. Others said, I tried, I couldn't get anything, but I've got enough of an idea to suggest something, and and then put in some theoretical situations. So that would be fine too.
Okay, and potentially if you do get onto a few different practitioners and they all give you a piece of the puzzle, can you submit it as if they've all contributed to your answer? So you've not just spoken to one and bang, 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 answered all these questions, but each of you have each given you something to go with?
Absolutely. Yeah, that's fine. Yep.
Okay. All right, thank you.
No, good questions. Thanks, Jessica. Are there any other questions, comments?
Is there any application that you know of to migration?
So applications for migration, was that it, Gordon?
Yes, with respect to dispute resolution.
That's a really, that would be an excellent question. No, I haven't, to be honest, I haven't looked into that realm at all. But if that was your area of practice or interest, and so much work in migration law, it would be wonderful to apply these principles in that context. But I'm sorry, I don't have any specifics, Gordon, no. Any other questions, comments? All right. Thank you very much for your participation tonight. I'll stop the recording and end the meeting now. And as usual, if there's any discussions, please think you crew, and let's start to exchange some ideas. I know you'll all gain a lot of momentum once we get that first assignment completely out of the way. All right, all the best, and we'll see you next week. Bye.